Good afternoon, and thank you for inviting me here, first of all. I will try to be as brief as possible this time, since some of the matters related to the fiscal part have already been presented by my colleague Cosmin Costaș in a very competent manner. I chose you from all of them with a message to pass. You are going to die soon, and I'm gonna let all others tell you whatever they want. I can't lie to you. I love you, but I'm fair and merciless. There is no escape. Slowly I place my right hand on your shoulder and you feel it. I say nothing. I bow my head and then I cover. I do not move. I remain faithful. I am more than a nurse, a relative or a neighbor. I shall escape. I shall release you from everything but your spiritual existence, which is eternal. The body you are going to relinquish will be nothing else but filth. The sun bursts in spaces unlimited. You are filled with trust. You laugh. You forget about your illness as I forget. You no longer see the doctors. You no longer care about your crying friends. I'm here with you. I banish all others. There is nothing to pity. I do not pity you. I congratulate you. These are the words of the famous American poet Walt Whitman for a dying person. I wanted to start my speech with these words, starting not only from the ambiguity of death, but also from the fact that regardless the concrete circumstances of death, we die the same, and the effects of death are the same. Despite this, the regulation of property effects of death, of succession, as we've seen, differ significantly from one country to another, even within countries or states whose system is integrated in the large Roman-German family. We are talking about the system of double transfer, which focuses on protecting the interests of the creditors to the succession, favoring the previous liquidation of the liabilities, or we talk about systems which are integrated in the so-called civil law countries, different in terms of determining the shares of the estate, establishing the reserved shares or the right to damages, or how to determine the estate. We bring all gifts in the calculation of the estate, regardless their time, or only those performed ante mortis in the last 10 or 5 years, proportionate by 1/10. For example, in a wide reform process regarding succession, the most recent in Austria in 2015, they removed from the scope of reserves the parents of the deceased, and they only maintained the children and the surviving spouse. So we see, or not to mention the institution of agreements as to succession or wills. The new elements brought by the regulation, and here I am talking about matters that will appear, matters regarding the integration or adaptation or certain concepts. It is enough to remind here the institution of unilateral or bilateral agreements as to succession, which are regulated by Article 25 of the regulation, saying that the admissibility of agreements, which is a condition of admissibility, and their enforceability are ruled by the law applicable to the succession had it been initiated when the agreement was concluded. That means that even if eventually the law applicable to the inheritance is, let's say, the Romanian law, based on the criterion of the last habitual residence, we see an agreement as to the succession. If I look at the German space, for example, this could produce effects in Romania. So its validity and admissibility, including the binding effects for the parties, might be subject to the German law. However, it has to be integrated in the Romanian law, because we will be in the situation, for example, to determine the extent to which there have been gifts under this agreement to see the shares. The French Cassation had the opportunity to rule on this in case of an Anglo-Saxon trust. What I would like to emphasize briefly is one of the key elements of the European regulation, namely the principle of the unity of inheritance. And then I will just briefly point out some fiscal matters and some matters related to the correlation between the capacity and the law on succession. And then I will conclude and give time for questions. As I was saying, one of the key elements of the regulation is the principle of unity of inheritance, and this principle is derived from the entire body of the regulation, both in the manner of setting the competent law, Article 21 of the regulation, the last habitual residence as objective factor of determining the applicable law. And I'm not going to insist now, because we no longer have enough time to determine what is habitual residence, what is the difference from domicile, because the domicile, if we look at the Article 85 of the Civil Code, this is a national concept, and it is declared. As a notary, I look at the domicile declared. And habitual residence means an investigation performed by the notary and gathering documents that would inventory the set of personal, professional, and family circumstances, the place where that person actually lived, as resulting from the entire case law of the European Court of Justice, Micheletti, Di Paolo, and so on. Thus, this unity of succession is focused on this concept of the habitual residence. Just a brief comment. I was trying to think to the specificity of these times we live on the way, in which private international law is trying to provide an answer to the challenges it is facing. Obviously, we are talking about the world of modernity. Nothing new here, and probably we could speak about it in every historical epoch, about the modernity of that specific time compared to previous periods. What would be characteristic for this world of modernity or for the recent human being, to use the expression of Horia Roman Patapievich? What would characterize the world of modernity today? Is it fundamentally different from the world in which from the world in which our forefathers lived? The answer is yes, it is different, because it is the first time when the present tense performs a double unification. On the one hand, we have the spatial unification, because the world of modernity is a world we meet wherever we look. We see it everywhere, in America, in Asia, in Europe, in Australia. So it is a world characterized by omnipresence, accessibility. We are accessible to one another, we are accessible to different traditions, we can choose different traditions. So the world is unified in terms of space, and it comprises the entire world. And then it's a world unifying time, history, because today we have a very accurate representation of each past epoch, each past era, starting with those very far in time. We have a very accurate representation of the Egyptian civilization or Sumerian civilization, of the classical Arabian civilization. We have a very accurate representation, often represented or reflected in an artifact, which is an interpretation, an accurate representation, not from the perspective of the proximity of contemporary elements, but maybe the most important issue raised by modernity today is the matter of feeling of belonging. To whom do we belong? Do we belong to the state of our city, of our nationality? Do we belong to the nation on whose territory we were born, whose language we speak? Or on the contrary, do we belong to the place where we settled, our center of life and interests, technically speaking, where our habitual residence is, to whose legal system we refer to or choose? So this is a redesign of this concept of belonging, and from here there is only one. We are only one step away to Sabini, who long time ago in volume 8 of his treaty on law, on Roman law, he referred to establishing the location of the legal relation, and of course here this location can not be related to the location of the goods which are part of the state, not to the cultural belonging of the heirs. It can only be related to the deceased. Hence, the last habitual residence. And unity, on the other hand, is expressed by the fact that I will, that pursuant to Article 22, I won't be able to select several laws on succession as allowed by the Hague Convention, which did influence somewhat the wording of the regulation, but I can only choose one law which holistically looks at the entire estate. On the other hand, when we locate the succession based on an objective factor, namely habitual residence, when we remove this criterion, especially when we are talking about a quite recent habitual residence, that cannot lead to the designated several laws that would govern the succession. Obviously, the unity of the estate has another dimension as well. There is an analogy between the criterion to establish jurisdiction, the general rule in Article 4 providing jurisdiction to the court of the last habitual residence, and the law of the law of the last habitual residence, or the law chosen by the deceased, the law of one of the countries either selected either at the date when the succession was initiated or on the date of the choice. Of course, this unity is not irremovable. As an exception, there might be, or it may be defeated, this unity, either by subjecting certain categories of assets to the territorial law on the ground that the law on their location would provide derogation from the legislation of that country. We remember Article 30 of the regulation. It is about countries like France, Spain, Austria, which, in order to protect agricultural activities or farms, create a special inheritance regime. And obviously such a regime will continue to be subject to the law of the place, to the local law. This is a positive aspect. Obviously, the defeat of this unity may occur as an effect of the renvoi when, for example, the last habitual residence of the deceased is in a third country.
34 din regulament.
Article 34 of the regulation is regulated the renvoi. This represents or is related to the specificity of the conflict of law. The conflict of law is a dialogue, actually. A brief comment. Someone was saying a story and said that a monk whose name remained forgotten was asked at some point about a believer, about the end of times, what will be the sign of it. After a few moments of silence, which only deepened the mystery of the answer, the monk answered, when the paths between people's houses will disappear. In other words, when people will stop having a dialogue, when people will stop visiting one another, when people stop interacting, when they live in micro communities, in solitude, without links, in other words, without unity. So the conflict of laws are precisely these rules of dialogue, because there is no uniform European succession rules that would govern the rules to calculate the shares and so on. So there is no material uniform system. But there is conflict of law that allows for gathering together a whole. Of course, when the conflict of law would send to the legislation of a member state, there is no, we cannot speak of renvoi. Everything is uniform. When the connection factor sends me to the law of a third country, by this involving both third countries and the countries which do not apply the regulation, UK, Ireland and Denmark, then we get to the matter of the renvoi, insofar as the conflict of law in that country does not accept the jurisdiction and would send the case either to the forum or to the legislation of another country. I'm not going into details here either. Article 34 of the regulation regarding the renvoi, due to the wording of the regulation, in the international significant doctrine, there are several viewpoints, especially when the renvoi is third degree or more, starting from the wording. It says, the application of the law of any third state specified in this regulation shall mean the application of the rules of law in force in that state, including its rules of private international law, insofar as those rules make a renvoi to the law of a member state. That's okay. That's first degree. B, to the law of another third state which would apply its own law. In other words, from the wording of the regulation, we understand that it can only the second level renvoi can be admitted. Some prestigious authors, and I'm talking about Professor Andrei Bonomi and Patrick Botelet, who in a paper on European succession law published by renowned publishing houses already at the second edition. So commenting on this article, they say that the interpretation of the final part, letter B, namely the law of another third state which would apply its own law, should be correlated with the preamble to the purpose, to the aims of the European lawmaker, namely cross-border recognition of authentic instruments. However, this is a unique opinion, because basically all other authors, either French, Paul Lagarde or Revilla or Dominique Bureau, not to mention German speaking authors, they say no, the right interpretation is the limitation to the second degree renvoi, because on the one hand this is clearly indicated by the wording of the text, so the very grammar, and secondly from a historical grounds, namely that this part of the regulation had been taken. So the European lawmaker found inspiration in the Hague Convention from August 1st, 1889, which no longer entered into force, but which is applicable in the Netherlands, a text which explicitly does not allow for third-degree renvoi and further. I'm not going to get into detail, but the question was, what happens if the third country, the law of the third state, would renvoi to the law of a member state or the local law? And here the German-speaking professors, who are quite pragmatical, say, well, in this case, however, we should reach teleological interpretation and bear in mind that a third-degree renvoi, if it is a renvoi to the law of a member state, it should be admitted, however, and applied by analogy, the provision from letter A. Of course, the majority argument now, because so far the Court of Justice did not rule on the matter, is quite debatable, in the meaning that letter A makes explicit reference to a renvoi degree 1. And on the other hand, from a scientific viewpoint, either I do not accept a second-degree renvoi and then I no longer look to the conflict of law in the third state, and if I accept it, then I should accept the will of that conflict of law to locate the succession by subjecting it not only to the law of a member state but to the law of any other state. So either I set a limit or I listen to it. I cannot adjust my position based on the result, taking into account its contents.
Legat de chestiunile de natură fiscală,
regarding the fiscal aspects, as we know, the regulation excludes from the field the customs, administrative, and fiscal fields. Now, because regularly in the international private law, these fields, or whatever exceeds the private law, would be where the state acts de jure imperi. So it's not a matter of a conflict of law, but just applying the territorial law. Although lately we more and more often see, including like the Professor Horvat's publication, a reference to the features of the contemporary legal modernism, the solution between private and public law, which is no longer acknowledged internationally. And I would refer here to the two papers from Fabrizio Cafaggi and Horatia Morvath. I also wrote down the same decisions with respect to tax applications, Eckerkamp with respect to the free movement of capital, but also discrimination, allowing for these amounts to be subtracted. The issue was that certain professors referred to unifying the fiscal matter of successions in the sense of reaching a single law that regulates both succession and its fiscal implications. Of course, these are just opinions. It's not an official perspective, in the sense that the fiscal credit is a supporting element that refers to the current level or the status quo, but the exercise of the succession planning entails not just taking into account the content of a foreign law, which might be more favorable, because they don't know that share of the estate, or it gives it a different approach, but also Fiscally speaking, when you conclude a law, its fiscal implications are also taken into account. And continuing the discussion, we conclude to an idea that maybe should be taken into account by the lawmaker in the further future of giving up the traditional principles of the fiscal law, of taking into account in successions the income acquired by the taxpayer, the heir, and to also consider the same parameters applicable to succession law, saying that the income is achieved where proceedings are started, but not in the sense of death, but in the natural planning of the author, and in allocating this to the law relevant for succession, be it habitual residence or the choice of law. This is, however, something that entails a political will or a willingness of the states to renounce these advantages. And here the two-speed Europe, which was not understood very well by Romania. There's a contrary perception, but I do believe it's quite viable, because a two-speed Europe or a several-speed Europe is a Europe with different integration intentions, taking into account the will of the states, not the Europe that divides the states depending on their geography, like border states or core states, but rather states that want more to reach greater unity. And this should consider the fiscal aspects as well, or maybe states that rather to preserve the traditions or the national regulations and are rather reticent to this, let's say, 2.0 integration in yielding sovereignty to Brussels. We also take into account the fact that Romania is not part of the regulation to same gender partnerships, nor to the marriage regime that entails the same time of implementation, but it has rather the most liberal legislation regarding divorce. You know, the argument for Christianity is the same, but the same essence leads to different realities. The impact, and this will be my final comment, so I won't focus on exceptions to the regulation because it would take quite a time. So the capacity as a general concept is under the national conflict rules. There is the pertaining article in the Civil Code saying that the status of the individuals is regulated by the national law, and this national law is the lex patriae, the state of which they have citizenship, and the those that have double or multiple citizenships, the law of the states with which they have the closest ties, especially the habitual residence. In this case, the lawmaker is quite European, more European than the German or the Austrian one, because they do not prefer their own nationality as the former law of 105/92, but rather presents both citizenships and looks for a proximity or a preference or a connecting element through this concept of habitual residence. This, of course, has certain advantages because the habitual residence can be changed, and this may also change the nationality of a person. The capacity to accept a succession or to waive it will be governed by the national law of the person according to the mentioned criteria. Also, protecting those that are not at full capacity to decide on their own matters will be governed by the same laws regarding the capacity to make this disposition. And with respect to the minors, we refer to Brussels 2 bis under a review that we know that grants jurisdiction to the state of habitual residence of the minor. Now, with respect to the protection, the Hague Convention of '96 regarding the jurisdiction of the applicable law on the enforcement and recognition of judgments, and also regarding parental responsibility that Romania is a signatory to. Nevertheless, the scope of the regulation includes those special or specific matters of this capacity that have also impact on succession, like the succession capacity, Article 23, paragraph 2, the capacity to conclude dispositions of property upon death. As we know, the capacity of the will is not subject to the national law, but to the law that would apply to the succession had it been initiated upon drafting the will or of that succession agreement. It's precisely to convey this foreseeability or predictability, for example, the criterion of habitual residence, which can change in time. So the lawmaker, the European lawmaker, subjects this to the law that rules the statute of the that would have been applied to the succession at the date of concluding the will. In this case, if we are to criticize the European lawmaker, we could say that they could have been a bit more generous, so as to allow for the implementation of either the alleged succession law or the national law, such as the Austrian law of international private law in '78, but the lawmaker stopped, however, and did not provide these dispositions, or it would have said that both to that hypothetical succession law or to the actual law applicable. Again, the validity of the merits of the succession provisions fall under the same law. However, the matters regarding the lack of capacity will not be ruled by the national law of the person, but by lex successione, which is capacity or lack of capacity to a disposition which are subject to the succession law. With this, I will try to wrap up. If you have questions, I am available with respect to any part of the regulation, maybe to leave room for questions. I would like to thank you.